somebody other than a lawyer is one of our consultants. This is the first I've done this. It's kind of fun.
Yeah.
Well, it's just.
Well, I'm sure it's only because guilt by association with Jonathan, right? So, you know.
Thank you. Thank you. I think Leanne's trying to actually organize our
She's
meeting.
trying to start us, yes.
Heaven forbid, but it has just hit 2 o'clock Eastern, so we should probably get started. So welcome everyone to the first of the Committee on Administration and Management meetings. We're going to start by doing a quick roll call, and the purpose of this is to make sure we can hear you. So if you can unmute and say here when I call your name, I would appreciate that. So I'll start with the members of the Committee on Administration and Management, who are the people who can vote on the recommendation, should that come up today. Aaron Nielsen.
Here, can you hear me?
I can.
Good.
David Apple.
Here.
Warren Belmar. Jody Bernstein. Marshall J. Breger. Amy Bunk.
Here.
John Cooney.
I'm here.
Bridget Dooling.
I'm here.
Tobias Dorsey. Fred Fielding. David Frederick. William Funk.
Here.
Robert Gerard.
I'm here.
Claire Green.
I'm here.
Allison Ho.
Here.
John M. Kamensky. Mohammed H. Misbahi, who's serving as the alternate for Eric Lepresti.
Here.
Jennifer New.
Hi.
Ann Joseph O'Connell.
I'm here.
Nina Olson.
Here.
Jesse Panuccio. Elizabeth Papez. Eloise Pasakoff.
Here.
Kate Shaw. Lauren A. Smith. And Jim Tazi.
Yeah.
Great. We have a short list also of individuals who are members of ACUS but who are not on the committee, and they will also have speaking privileges during this meeting. So that's Robert Stone.
Here.
Stephanie Tatham.
Here.
Deborah Aiken, who is serving as the alternate for Jonathan Doles.
Present.
Andrew Simons, who is the alternate for Carol Ann Siciliano. Christina McDonald. And Peter J. Constantine. Is there anyone I have not called or who came in after I called them who is either a member of the committee, a member of ACUS who is not on the committee, or an alternate for either of those kinds of people?
Yeah, hi, Kate Shaw. I think I joined after you called my name.
Great.
And this is Helen Serastio.
Sorry.
Sorry, John.
Can you, I think there were 2 people who said something.
Go ahead.
Helen Serastio with EPA.
This is Dave Rosker for Charlie Maresca, liaison from the Office of Advocacy.
And I'm Jonathan Weiner here as the consultant, but I'm also a public member of ACUS, but not on this committee.
Okay.
This is Lane Murray for Christina McDonald.
Great. All right. I think I have everyone. All right, and with that, I will turn it over to Matt.
We can't hear you, Matt.
You'd think, Aaron, that I could get this right, but I can't. Thank you, Leanne. I know that our time is precious. There's only been 2 hours allotted for the meeting, and I don't want to cut into it, especially since Aaron is chairing, and Aaron runs a tight ship, which I mean is a compliment. So let me just thank all of our members for participating this afternoon, especially on a Friday. We have a lot of talent in the virtual room here. And then I'd just like to especially thank our two consultants, Lori Benier and Jonathan Weiner, for providing us and the committee with an outstanding report that I think will serve the committee well and also the members at the plenary session. So with that, let me turn it over to Aaron. And I just before I do that though, Jonathan, I think that I don't know exactly how this works under our governance since you're not a member of the committee, but you are recused from participating in the project as an ACUS member. You'll be participating solely as a consultant.
Okay, thank you, Matt, and great.
Okay, thanks, Jonathan.
All right, well, welcome everybody. I'm excited to do this. This is going to be a lot of fun. This is a pretty big group and we're doing it on Zoom. So we're going to do our very best. I suspect, like most of you, that we're all kind of Zoom zombies at this point. So, you know, grit your teeth and persevere for a couple of hours. I think even though our time is limited, I think it'd be useful for everybody to quickly introduce themselves, especially I know some of you have not done one of these meetings before, so we can get to know who we are. It'll be easier to have a conversation that way. I'll start with myself. I'm Professor Aaron Nielsen. I teach at Brigham Young in Utah. I've been a member of ACUS since 2018, and I've been chairing this committee for a couple of years. So I'm starting to kind of figure it out, but there we go. So I'm not sure the best way to go down the line. How about we use the list of invitees, and if Leanne, if you could just say the person and then they can introduce themselves.
Sure. Okay. So alphabetically, David Apple, you're next.
Hi, I'm Dave Apol. I am the General Counsel at the Office of Government Ethics, and we happen to be looking at some of our regulations to do a not periodic, but a review of. So I'm interested in the topic.
Next up is Amy Bunk.
Oh, sorry. Amy Bunk, I'm a senior fellow. I'm an attorney advisor at DHS.
John Cooney.
I came from 5 years at OMB working on regulations and 45 years of litigating cases in court on administrative agencies.
Bridget Dooling.
Everybody, Bridget Dooling. I'm a research professor at the GW Regulatory Studies Center, where I joined just about almost 3 years ago after serving over 10 years at the Office of Information and Regulatory Affairs.
William Funk.
I'm an emeritus law professor at Lewis and Clark Law School, where I taught administrative law for 35 years. Before that, I was an assistant general counsel in the Department of Energy, where I was responsible for making sure the regulations were all lawful. And it was only found unlawful once by the DC Circuit.
Robert Gerard.
I'm a senior attorney with the Office of the General Counsel at OPM.
Claire Green.
Hi, Claire Green. I'm the staff director at the Social Security Advisory Board.
Allison Ho.
Hi, I'm the co-chair of the Appellate and Constitutional Law Group at Gibson, Dunn and Crutcher.
Sorry, I absolutely just lost track. Did I call Allison Ho? Great. Okay. John Kamensky, who's not here. Mohammed Misbahi.
Hi, I'm from the Taxpayer Advocate Service at the IRS, and I'm excited to see Nina Olson here as well, also our former National Taxpayer Advocate.
Jennifer New.
Hi, everyone. Jennifer New, professor at University of Chicago Law School.
Sorry for mispronouncing your name. And Joseph O'Connell.
Hi, I'm Anne Joseph O'Connell. I'm an admin law and con law professor at Stanford. I termed out as being a public member of ACUS, and now I'm a senior fellow.
Nina Olson.
Hi, I am the Executive Director of the Center for Taxpayer Rights and a Senior Fellow of ACUS. And before that, I served as a public member in my capacity as the National Taxpayer Advocate, where I spent and continue to spend my life advocating that IRS and Treasury update their regulations.
Eloise Pasikoff.
I'm a law professor at Georgetown, and I've been a member of ACUS for 2-ish years.
Kate Shaw.
Hi, Kate Shaw, professor at Cardozo Law School in New York City, public member of ACUS and a member of the committee.
And Jim Tozy.
A former member of Tulane faculty, spent some time in the government, and now I'm a senior fellow at ACUS.
That's all of the members of the committee who are here. Oh, Aaron, you're muted again.
That's because I chastised Matt for that problem. So there we go. That is karma. I think it'd also be helpful if we could just, there aren't that many more, if we can ask the other people who aren't here to introduce them, who aren't committee members, to introduce themselves as well. So can you continue down the line?
Sure. I think we'll just do the other members of ACUS who aren't on the committee, the ones with speaking privileges. Okay.
Yes.
Robert Stone.
Hi, I'm Robert Stone. I'm an OSHA economist, and I'm also OSHA's representative to ACUS.
Stephanie Tatham.
Hi, I'm Steph Tatham. I am a youth voting member to ACUS. I've filled Bridget Dueling shoes, and they're big shoes to fill.
Deborah Aiken.
I'm Deborah Aiken. I'm the Director of Regulatory Analysis at the Department of Transportation, standing in for Jonathan Doles.
Helen Saracio.
Sorry, slight delay there. Hi, I'm Helen Saracio. I am the newish Associate General Counsel for Cross-Cutting Issues Law Office at EPA.
Lane Murray.
Hi, I'm Lane Murray for Christina McDonald. I'm an economist at DHS.
And Dave Rosker.
I'm Dave Rosker, an Assistant Chief Counsel in the Office of Advocacy, and for Charles Maresca, who is our Director of Interagency Affairs and the liaison to ACUS from Advocacy.
Great, that's everyone now.
All right, perfect. Thank you, everybody. So I'm going to briefly kind of set out the ground rules of how this is going to work. First of all, schedule-wise, we are 2 hours today. We'll do 2 weeks from now, we'll do another one of these meetings for 2 hours. If necessary, and it probably will, but we'll see, 2 weeks following that, we will do the third and final 2-hour session. We've heard a little bit about who has ground rules to speak. I have been given a script to make sure that everybody understands the rules. So just bear with me here. So here's the language. Please note that only ACUS members, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, please keep your microphone on mute and either use the Zoom's hand raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. And then when you're done, mute yourself again. My personal preference, please use the chat function to say that you have a comment. Because I have 2 screens, I can't see everybody at once, but I do see somebody when a chat function pops up. So if you look at the bottom of your Zoom screen, there will be a chat function, say comment, and then I will see that there's somebody in line to speak. So if you could do that, that'd be really helpful for me. Also, if you are an ACUS member, someone who has speaking privileges here, please use your webcam to the extent you can. I recognize that we all are surviving, so sometimes that's just not doable, and that's totally fine. But to the extent that you can, it's easier for us to have a real conversation if we can see each other. So it's useful for you to turn on your webcam, especially when you're speaking, but to the extent that you can more generally, that's very helpful for us. With respect to participants other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such participants at appropriate points, and we will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature and wait until I call on you. You can then unmute yourself and then mute yourself afterwards when you're done. For all participants, please use the chat function only to indicate that you'd like to speak. Please do not hold any sidebar conversations or discussions or substantive comments in the chat function. It's just too hard via Zoom for us to have two conversations going at once. Only members of the committee will have a vote. Please do not vote unless you're a member of the committee. We have a list. We are not going to have a real vote today. I am 100% certain. Today is going to be a conversation. So we might have some straw votes along the way. For straw votes, I also would just ask the committee members to vote. But even then, I suspect most of the time it's just going to be a conversation and kind of by consensus. And by the time we're done, probably next meeting or the following meeting, then we will have a vote. So with that, we're going to get started. And this is my thought for how best to go about doing this. Thank you very much to our committee, to our, what are they called? Our consultants. I was going to say like commissars, and I'm like, that can't be right. So our consultants, what we're going to do is we're going to let them speak to us for 5 to 7 minutes, introduce themselves, explain the project. Then I will take it over from there. Today, I think we're going to focus on the recommendations, not the forward or the intro. Once we get once we know what our recommendations are going to be, then we'll decide how best to do our introduction to the recommendations. But before we get into any of that, let's turn it over to our consultants, Jonathan or Lori, whoever wants to go first.
Sure, I'll go first. Thanks to Matt Weiner and to Aaron Nielsen as chair of ACUS and the chair of the committee respectively, and to Reeve Bull and Todd Rubin and Leanne Shriver at ACUS for organizing this. So I'll start with introductions and then just a few background comments, because one thing I know about lawyers is you actually read. So we don't have to tell you everything that's in the report. I'm Lori Snyder-Benier. I am the Julie Plant Granger Associate Professor of Energy Economics and Policy at the Nicholas School of the Environment at Duke University. And I am also currently serving as the Senior Associate Dean for Academic Initiatives at the school. Of course, this work was joint with my colleague, Jonathan, who will introduce himself now.
Hi. Yeah, let me echo my thanks to Matt Weiner and Aaron Nielsen and Reeve and Todd and Leanne and the ACUS staff. I'm Jonathan Weiner. I'm a professor at Duke Law School and also a professor at the Nicholas School of the Environment and the Sanford School of Public Policy at Duke. And I am a public member of ACUS, but as Matt Weiner mentioned, and by the way, I believe no relation between Matt Weiner and me, but as he mentioned, I'm recused from my role as a member here. I'm serving as the consultant. Thank you.
Okay, so the report that you have from us is titled Periodic Review of Agency Regulation. Despite repeated calls for retrospective review of agency regulation over many decades, progress on that front has been limited. One of the goals for retrospective review is regulatory learning, which can go beyond sort of a one-time look back to a process that promotes more ongoing updating and learning. And periodic review might be one way to move towards such an ongoing or continuous learning process. So ACUS has recommended periodic review in the past, for example, saying in its recommendation 1995-3 that, quote, systematic review processes should provide for a periodic ongoing review, unquote, for which agencies should consider, quote, for example, regulations reviewed every X years, unquote. It also said in its recommendation 2014-5 that, quote, agencies should periodically evaluate the results of their retrospective reviews. So this report picks up on that history of recommendations from ACUS. And we look at systematic study of how widely or how well agencies actually practice periodic review. We conducted the study to gain a better understanding of periodic review across the federal government and to offer our insights into best practices for such periodic review. So for this report, we define periodic review as a type of retrospective or ex post review of the performance of existing agency regulatory actions. Periodic review differs from some types of retrospective reviews, however, in that these periodic reviews are repeated multiple times, often at regular intervals, for example, every X years. When undertaken regularly, periodic reviews can lead to ongoing learning and formulating new rules rather than only revisiting past rules. So our report recognizes that there are both pros and cons to periodic review, so it'll be more appropriate in some settings and less appropriate in others. And the arguments for retrospective review is both that things accumulate, right, in the Code of Federal Regulations, and over time there may be more likely to have duplicative regulations or regulations that conflict with one another or are no longer relevant. So cleaning the books of those rules makes sense. And also that things change. And that might be because of changing technology, changes in the science, social values and norms, industry or market structure, a variety of things could change. So then the justification for periodic review is because things keep accumulating and keep changing. And so these reviews need to happen more than one time, especially when the change is rapid and we expect to learn more over time. Periodic review can also help avoid mismatches in which the rules that seemed optimal ex ante become suboptimal over time as conditions change. But of course, periodic review also has costs, the most obvious of which are staff time that it has to be devoted to doing these reviews from other things that agency staff may be doing and the expenses of those reviews. But there are also costs in terms of uncertainty and instability, both for the agency and for the stakeholders. So our report suggests that periodic review is not ideal for every rule, but rather makes the most sense when the gains from learning and the cost of policy mismatch over time are most likely to outweigh the instability and uncertainty costs of periodic review. So in the report, we use two different methods. We begin with a detailed document review, which I should point out we were aided in this by a very capable joint degree student as a JD and Masters of Environmental Management student, Molly Bruce, on a detailed document review to identify the ways in which periodic review has been used in statutes and executive orders and in the agency's own policies. And we then selected a subset of agencies based on that documentary analysis with which to conduct detailed in-person interviews. And with that, I will turn it over to Jonathan, who is going to discuss our findings.
Thank you, Laurie. So I'll briefly summarize what we found, and you have much more detail in the written report. So as we identify in section 3 of the report, we found that calls for periodic review appear to be fairly widespread and yet unevenly implemented. So we may be more familiar with several presidential executive orders that have called on agencies to conduct periodic review as early as President Carter's Executive Order 12044 in 1978, which in section 1 required agencies to, quote, periodically review their existing regulations, unquote. President Clinton's Executive Order 12866 from 1993, still in force, which in section 5 asked each agency to, quote, submit to OIRA a program under which the agency will periodically review its existing significant regulations, unquote. And President Obama's Executive Order 13563, section 6, also asked for a plan for periodic review. We then looked at statutes enacted by Congress that apply generally across the government, asking for periodic review. And we identified at least two. If there are more, we'd be happy to include and discuss those as well, but at least two major statutes that call for a version of periodic review across the government. One is the Regulatory Flexibility Act, which in section 610 calls for agency policies that may have a significant economic impact on a substantial number of small entities to be reviewed within 10 years. The statute says within 10 years. It's not quite clear whether that's to be repeated afterwards on additional 10-year cycles. And the second statute here is the Foundations for Evidence-Based Policy Act, enacted in January 2019, so relatively recently, which calls on agencies to develop systematic plans for evidence building and evaluation And OMB has issued guidance under the Evidence Act, calling these plans learning agendas and noting that they should be updated every 4 years, at least parts of them. Then we looked for statutes that apply specifically to particular rules or particular agency programs. And there we identified a significant number, which are listed in Table 1 on page 20 of the draft report. So we found more than 20 statutes which use a word like periodic or periodically to call on an agency for a particular rule or program to review those rules periodically, without stating the number of years, or the time interval, but just the word periodic or periodically. And then we found another 20 plus statutes which do specify a time interval every X years, such as every 2 years, 5 years, 8 years, 10 years. And there's a variety of those time intervals indicated in these statutes. Our table is not exhaustive, and we'd be glad to hear of additional examples. And in section 3.3 of the report, we discussed several of those specific statutes addressing a number of key agencies. We also noted in section 3.4 of the report that some agencies have adopted rules on rulemaking or a kind of cousin of that idea, on which ACUS has previously issued its own report and recommendation. Agency rules or policies calling on the agency itself to conduct a version of periodic review. And those could range from a word like periodically to a specified time interval, or even to a sunset requirement that the agency's rules would expire if they don't review them, such as in the recent HHS rule made final in January and then at least postponed for a year in March. And then in section 4 of the report, we described the interviews that we conducted with staff at several agencies, at OMB, OIRA, and at several regulatory agencies. And we're very grateful to the agency staff who gave their time for these interviews, and to the ACUS staff who helped us arrange these conversations. So in section 5, we collect our key findings, and let me just identify several of them here, and then I'll conclude. These key findings include, first, that calls for periodic review appear to be widespread in executive orders, in generally applicable statutes, and specifically targeted statutes, and in agencies' own policies. Second, the agencies that we interviewed shared the understanding of periodic review as we have described it or defined it. Third, the implementation of periodic review appears to be uneven. Some agencies have made periodic review a regular part of their practice. Others have done much less, and that can also vary within an agency. So for example, even within one agency, such as EPA, it appears that periodic review has become a much more regular practice of the every 5 years reviews for national ambient air quality standards under section 109, but it's been more of a struggle for EPA to conduct the every 8 years reviews of the technology-based emission standards for hazardous air pollutants under section 112 of the Clean Air Act. A further finding is that agencies' staff told us that they thought their agencies adhered to the periodic review deadlines most faithfully, where the deadline is set by statute rather than, say, by executive branch order or policy, where it may be enforced by litigants in court, and where it may affect renewed funding, such as where Congress renews the funding for a program every 5 years. That could powerfully influence the periodic review. That doesn't necessarily mean that those are the best or optimal periodic reviews, because that, as Lori mentioned, that can depend on the relative benefits and costs of conducting the repeated reviews. The agencies that, in our judgment and in the interviews that we conducted, appear to have undertaken periodic review most successfully, appear to have done more than just meet the deadlines and more than rush to meet the deadline in an episodic way or cramming for the deadline. They appear to have incorporated the ongoing process of learning and updating into their regular agency practice and culture. And so they have, in some ways, transformed the periodic review from a one-time or episodic look back into a continuous learning process. And examples of that include the EPA review of the National Ambient Air Quality Standards under the Clean Air Act and the USDA and HHS reviews of the dietary guidelines for Americans. And those also notably employed staffing plans or patterns that organized and enabled staff to keep track of new developments on an ongoing basis, rather than just returning to the review at the end of the time interval. And they also tended to have, not always, but tended to have expert advisory bodies such as EPA's Clean Air Science Advisory Council, CASAC, or the Dietary Guidelines Advisory Council that helps USDA and HHS. So external expert advisory bodies. Just a couple more to mention. Some agencies looked to stakeholder input to identify the need for reviews. And at least one agency, DOT, tracked data on requests for waivers and variants as an indicator of when a review might be needed. If it was getting a lot of requests for waivers and variants, that might indicate. And I know there's a thoughtful comment on this issue by Jason Schwartz. The agencies reported to us that not all of these periodic reviews lead to substantive regulatory changes. Some of them might confirm that the existing standard is appropriate. It's really when there's a significant change in the science, technology, social conditions that a change might be warranted. And so the mere fact of requiring periodic review every X years did not necessarily result in policy change every X years. The last point I'll add here is that the time interval or the optimal period or frequency seems to us to be an understudied variable here, that the frequency is sometimes specified by statute every 2 years, 5 years, 8 years, 10 years, but without much explanation or any explanation of why that time interval was selected. And we found little, if any, analysis in the agencies of why that time period was appropriate or not, or what would be the optimal time period. And we make some suggestions in the report about how to evaluate the optimal frequency of these reviews. And I also just note that I appreciate the comment that Bill Funk submitted on this question, which I thought was very interesting. Okay, with that, I'll conclude our introduction and look forward to the committee's conversation. Thank you.
Perfect, thank you. So what we're going to do now is we're going to go to the recommendations themselves. Leanne, who has the hardest job, is going to drive for us and put them, I believe, so we can see it, correct, Leanne? Is that going to, here it is,
Yes,
perfect.
can you see it now? Great.
Yes, we can see it. So please go to the recommendations. We're going to do that before we get to the introduction. And the way that I think it makes sense to do this is to go down the line on a recommendation by recommendation basis. If someone wants a broader point that's related to the suite of recommendations we're talking about, we can have a conversation about that, which I think sometimes it might make sense to do. But I think it also makes sense just to go, one by one, go down the line. We're gonna have 2 or 3 meetings, so everyone will get a chance to circle back and see how it kind of fits as a harmonious whole. But that's kind of the plan. I see Bill is in the comments. I was gonna mention him, but he's right there. Bill had a comment that is kind of a larger one that I'm not quite sure where it fits in. So Bill, we're lucky that he's here. I'm gonna let you have a moment of a comment, Bill, but as we come to the recommendations where you see that your thought is most applicable, I also urge you then to kind of chime in with recommendation language or things of that sort. So with that, I've got a couple of comments. Let me see. Bill, can you have the comment?
Yes, I do. Thanks, Aaron. And I wanted to sort of say it up front because I think it applies to this first set of recommendations, not the latter sets of recommendations that are in here. But my idea that the idea of setting ex ante a certain number of years, every 5 years, every 2 years, every 8 years, whatever the number would be, is probably not, I think, the best way of doing it. It's one way of doing it, but another way of doing it, which I think is preferable, would be to say that we set a date for a particular retrospective review. And then when we do that retrospective review, we decide on the basis of the information we have at that time when the next retrospective review should be, which will be more informed than it would be if we say every 5 years, because after 10 years and 2 retrospective reviews, we may know really we don't need to do this very often, or we need to do it more often, but we're still set with this every 5 years type of thing. In addition, under this recommendation, as I read it, it's very hard to figure out what you're supposed to do about rules that occur after you've set this identification. In other words, recommendation number 1 says identify the rules or categories of rules that are subject to statutory. Then in the number 2, for rules not subject to them, agency should die whether to do it, and then what we go to how long it should be. But the question I have is, well, what about a rule that is all new, brand new, that occurs after you've gone through this process and identified these things? It doesn't seem to me that this recommendation really addresses that. And so I think we should distinguish between existing rules that we should go and make a schedule to when at least to do the first retrospective rule, and then a separate recommendation as to what to do about rules that occur subsequent to this. And that's why I say each rule, when you do it, should set its own retrospective review date. And then the next retrospective review is set the next retrospective review date. So it wouldn't be every 5 years, it would be when they decided to do it. And as I say, I think they'd be more informed. But as an initial matter, I think specifying how you deal with the rules that occur newly after you've done this initial identification, and I don't see how that's really identified here, and I think it should be.
All right, Dave? Dave Rosker?
Yes, hello. Thanks for the opportunity. 1 second, get my video going here for you. Good afternoon. My comment is one that we run into with regards to 610 reviews, and it's that the scope of the agency 610 reviews tend to be focused on the 4 corners of the notice of final rulemaking that they issue. That is to say, they define the rule as a narrow concept of what they need to be reviewing, rather than the broader concept of what is the rules that a particular industry may need to comply with. In that vein, I think the question is whether periodic review should be focused on the question agencies should need to be asking is, what is the appropriate scope of a periodic review? And I would suggest that the appropriate scope of the periodic review needs to be focused on programs and the industries that they affect, rather than necessarily the way that the agency itself has organized its rules, particularly where we have agencies that make frequent updates to a single program through a variety of different rulemakings. I hope I've made the concern there clear, but it does lead to, unfortunately, narrow retrospective reviews, which undermines the ability of the agency to actually ask the question about whether or not there are better ways of doing what they intend to do.
Right, thank you. By the way, I'm not, dismissing anybody. We're just going to go through the list, and then we'll start getting into the meat of the recommendations. So thank you for that. Jennifer?
So this is just a really narrow suggestion. I'm just, per your encouragement to just kind of go through each recommendations. This is just a comment on number 1. I thought it was just ambiguous or worth clarifying whether agencies should identify the specific rules like publicly. Like, is this meant to be just internally identifying them or publicly identifying them? And I at first I thought you meant internally, because maybe I thought the first kind of section is what like internal processes within the agency, whereas like the second heading, that is performing data analysis and soliciting public feedback, was more like external facing. But then I see that number 4 and 5 are also external facing because it's about soliciting public input. So my suggestion is either to include the word publicly in number 1, or to reorganize this so that 4 and 5 are in the next heading. So it's clearer that the first section deals with internal kind of processes within the agency, whereas the second is more external facing.
All right, thank you, Robert. We'll get to that. We're all going to circle back. I just want to get everybody's thoughts, and then we'll go into line by line.
Oh, okay.
So I'm not being dismissive. I just want to get everybody's thoughts, but then we'll jump in. Robert?
Sure. The sentence agencies should identify the specific rules or categories of rules, if any, that are subject to retrospective rule. Rules or categories of rules can be unpacked. And I think that, there's a question in my mind about when we're talking about retrospective review, are we talking about, for substantive rules, are we talking about final rules or parts of the Code of Federal Regulations? And since rules are defined very broadly under the APA, are we just talking about rules of general applicability and legal effect, or are we also talking about statements of policy, interpretive rules, and guidance documents? I think it might be helpful either in recommendation 1 to state that those are the kinds of things that agencies should think about, or if it's less cumbersome, at least include some definitional discussion in the preceding background section.
All right, thank you. Eloise?
So this is a question about the connection between the comment in the report that agencies didn't find the 610 reviews to be all that effective, and wondering whether, as well as the idea that agencies were then maybe redefining things to get out of the scope of 610 review. And so wondering, in light of that comment in the report, whether this section here should do something beyond just telling agencies which kinds of rules to identify, but furthering some goal of making the statutory requirement that they review under 610 actually effective. So I'm not really sure whether that would go in this section or in a later section, but I didn't want to lose it here because I think it connects to the incentive of agencies deciding what kind of rules need to apply. I also have to go at 3 o'clock, so I'm apologizing for voicing that and then leaving soon.
Okay, thank you. And Kate?
Also, just a little sort of small observation on 1, and I just wasn't sure about the language, the 2 words, if any, only because if 610 itself does actually set forth requirements that these significant rules, substantial impact on a number of small entities or whatever the language is, the if any language does seem a little bit, to Eloise's point, to reserve to agencies the discretion to define as 0, and that might be right? No agency rules may qualify under 610, but I just didn't know if should identify any specific rules or categories of rules somehow to something that doesn't use the words if any. It just sort of struck in my craw a little bit.
All right, perfect. All right, thank you, everybody. I promised we were going to go back and loop all of those in. I just wanted to hear everybody's thoughts before we got started. So I think it makes sense for us to look at the text of recommendation 1. For Bill, for your point, I think it's well taken. I think we can talk about what we mean by periodic review. So let's kind of focus on what we mean by periodic. For Dave's points, and I think Robert's points as well, we should talk about what we mean by rule, which I think is important. Do we mean rules? Do we mean programs? What exactly do we mean? And then I think Jennifer's point about whether we want this to be internal or external matters. And then Eloise's point, I think, is good. And we have to, I don't know if we put it here or we put it somewhere else. So I think the order of operations, it makes sense to me, would first say, let's talk about Jennifer. Then we'll go to, so we're going to talk about what do we mean by identify? Is it internal or external? Then let's talk about what we mean by rule. And then let's talk about what we mean by periodic, which I think are the 3 kind of things that we're juggling with. So Bill, if you could give me 1 second, I'll get to you. But let's talk first about maybe to the consultants. Is your thought that this should be external or internal?
So
Lori or Jonathan?
Yeah. I think our idea, and I should say that the recommendations, of course, were also were not only what we drafted, but also the ACUS staff helped revise and make them appropriate for the ACUS committee. But I think our initial idea was that it was a more of an internal function for the agency so that it would start to consider the timing of or the frequency of the intervals and really just to recognize which rules were already covered by statutes or executive orders, et cetera, that asked for periodic review, since we found a large number, but not necessarily a lot of implementation. But I take Jennifer's point about that maybe it should also be public. Where that goes in the recommendation document, I am agnostic.
Okay. All right, Bill, I promise I'll get back to you. What's your quick comment?
My quick comment is if there was general support for my idea of providing, at least as an alternative, the idea of doing setting the review time at each time you do the retrospective review, I would, before the next meeting, write up the changes in the language without changing any of the policies, because I think the policies that we are discussing go in either case. So I would not want to do any wordsmithing today about my proposal, but just have the idea, is this something that should be followed up on, in which case then I would provide language that people could deal with at the next session.
Okay, I think we'll get to that. That's going to be when we talk about the word periodic. So let's just put a pin on that and we'll get a sense of the room when we get to periodic. So let's first talk about the question, internal or external. Jonathan thought as they were working on it, this is internal. Internal makes sense to me here as well. I also think there's value in external, but for the logic of the document, it makes sense to me for this to be internal. This is focusing on what the agency is supposed to be doing. And then the second question is, after they know what they're doing, how are they going to convey that to the public? So that's my thought would be internal, but I want to hear what people think. Reactions. Maybe Jennifer, it was your question or your comment.
For what it's worth, I agree. I agree that it makes sense organizationally that this section talks about it internally, but then I would suggest deleting 4 because I think it doesn't belong in this section and it's duplicative of 6, 7, and 8. And I'll also observe briefly too that 7 itself talks about the external part of it. It says agencies, I think, should provide public disclosure, including which rules are subject to periodic retrospective review. So anyway, organizationally, I think it's cleaner to think about this one as in this section is internal and then the next is external. So I would delete 4 then.
Okay, so Jonathan,
we can talk about it when we get to it. It's all about public comment and.
Correct. Jonathan, I'll let you respond to Bill's point when we get to the word periodic. So let's just save that thought for now. Bill has a point on internal versus external. So Bill.
Yes, I mean, it seems to me that in terms of trying to figure out what laws apply to the agency's regulations, that's an internal process perhaps, but it's certainly we want them to identify after they've gone through that internal process to identify what in fact they have identified. That's publicly available. I don't think anybody should disagree about that. So how you phrase it's a different thing. And I think publicly identify, it tells, well, which ones have you identified as opposed to how you have actually figured it out. But however it's worded, we certainly want to make it public which rules are indeed subject to this retrospective review. And then in number 2, that's where you go to the public to help you in making that determination.
I mean, my reaction, and again, I'm going to take comments. My reaction is I kind of like Jennifer's organization. I don't think I disagree with you at all on the substance. The first one would be analytically, like, what is the agency doing? So section 1, not just comment 1, but or recommendation 1, the entire first section would be about, hey, this is what agencies ought to be doing. And then the second general suite of recommendations would be public facing. I think we would add a new one that would say agencies should tell the public which categories of rules, which rules or categories of rules are subject to periodic review, period. And then we talk about what that would look like. That's, for me, that's how it structurally makes sense. But I want to make sure that everybody else is on board with that. Is that what your idea is too, Jennifer?
Yeah, I agree.
Okay. Nina Olson has a thought.
But you're going to, when you get to recommendation number 2, that's going to be asking the public to participate as well, correct? That's not going to be solely internal.
Recommendation 2 or like
recommendation number 2, yeah.
So you're saying that when they decide whether they should make things, which rules should be subject to periodic review, that should be in consultation with the public?
Yeah, the ones that aren't statutorily or regulatory required to do it, we're now making a decision whether or not to do retrospective review of rules that aren't required to be done that. Then the recommendation later says we should seek public input on that. And so that's not just a totally internal matter.
Well, I mean, it is internal in the sense of this is what the agency is going to do. This happens to be an internal thing that requires talking to the public, but it's not in the sense of, it's still an order of operations for the agency. Whereas we're gonna get to external, where they're gonna share what they do, like their meta project. This is just how they design their project. Anyway, let's keep hearing from other people. We don't have to make any decision yet. Nina Olson.
Well, I know that we've addressed this in 4 about the public, but to me, that seems after the fact. I think that the choosing of what, and maybe this goes to 2, that the selection of what you're going to review needs public input as the agency is making that decision, because otherwise it may in weighing all these factors, it may be looking at it solely from the agency's perspective and not from the perspective of the persons, entities, et cetera, that are governed by that rulemaking. And I also think that the public, there would be differences of opinion of what's required statutorily. So I weigh heavily, and I think that you could do this under your construct of this is what agencies should do, and then this is how how the agencies should interact with the public. You could do that, but you need stronger language, and you need sort of recognition language in 1 and 2, or clearer language that says this is just part of the step, and you can't really do 1 or 2 without input from the public.
Okay. So somebody else, thoughts? Well, if no comments, it seems to me that we are all, unless someone disagrees, we're in agreement on conceptually what we're trying to do here, which is we think that they should identify what rules are either required or discretionary, and we think they should tell the public, and they should solicit the public's input in doing that. Now the question is, how do we put that on paper? And I like the idea that we'd make them analytically separate, but maybe we don't have to. Maybe I'm wrong about that. Eloise, I hate to call on you, but you are so good at this. What are your thoughts? Do you think we should do this organizationally as 2 sections, or can we do both of those ideas in the same section?
Thank you.
Eloise?
No, I'm here. I had to unmute and find video and all that. I don't know. Do I do the law professor sort of pass thing? And maybe see what Jennifer thinks, because she's the one who broached it to begin with. So I don't know. I'm of 2 minds the way you are. Because there's 2 different versions of the input and the soliciting input from the outside going on.
Well, I mean, I guess I'll let Jennifer respond. If we were to say agencies should externally identify Well, that means by definition, they're also internally identifying because you can't externally identify unless you have internally identified. So would that help? Would that solve the problem a little bit, Jennifer, if we made it external facing? Because by definition, you can't do external until you've done internal.
I mean, I agree with you, Aaron, with what you said, which is I think substantively everyone's on the same page, and it's just about how to organize it and present it, you know, to the audience. And I don't know, I still maintain that I think it just makes sense. The whole first section is clearly talking about like the agency's internal deliberative process. And I think nothing about, you know, moving everything to the second tranche of recommendations to be external facing is in conflict with, you know, having the public be involved in the identification of these rules. I mean, all of the recommendations speak to that. So, but I don't feel strongly. So, I mean, I'm fine with anything.
Okay, Bill says he has a quick solution.
Yeah, I mean, I think if you started recommendation number 4 by saying in making the decisions in recommendations 1, 2, and 3, agency should seek public input.
What do you think, Jennifer?
Bill,
Does that
have you
work for
seen
you?
6, 7, and 8? I mean, 6, 7, and 8 are all about public comment and, you know, interaction with the public.
That's right, though. That's for a different type of question.
that's-
6, 7, and
That's
8
when they
are
do
about
the periodic review. though.
correct. Are as you do the periodic review, this is what you're doing as part of periodic review. The first tranche or suite of recommendations is when do you do periodic review?
Can I,
Right.
Aaron, do you mind if I jump in for a second?
Of course, take it.
I was just going to say, I think maybe what Jennifer is identifying is that 7 alone feels like it should be in the first section because that's specifically about providing disclosure of the regime as a whole, whereas the other recommendations are about during the actual review process.
I think that is correct. Thank you, Leanne. Okay, so how about this? Let's just go back to 1, 2, and 3. I guess number 4. Let's try Bill's language in 4. In making the decisions outlined in recommendations 1 through 3. You know, public input is important, and we'll get that language when we get to 4. But then between 4 and 5, how about we move up number 7? What is currently number 7, and put that between what is 4 and 5, and put that idea there.
I apologize that this is going to look terrible in red line.
Okay. All right. Conceptually, does this make sense for people? We'll, like I said, we'll go through the individual language. We'll figure it out. But I want to make sure that at least conceptually, we're all on board with this. Going. All right. For now, we're in. Let's go back to recommendation 1. That solves the public versus external thing. So let's get rid of that first comment. So we know what we mean by that. Now the question.
Sorry, Aaron. So just to be clear, I mean,
sure.
I think what you're doing is you're introducing that public aspect into this first section, in which case, I think we mean agencies should publicly identify then, right? The specific rules or categories of rules to facilitate this public comment later.
Doesn't comment 4 do that?
You mean
the revised
recommendation
comment
4?
Yeah, the revised recommendation 4. Can you scroll up so we can see the language that Bill added? Oh, there. No, it's on that page. In making the decisions outlined in 1 through 3, they should identify. Does that not do it for you?
I mean, it doesn't make, it's like, I think of it as like the agency's proposed rules that they think should be the subject of this review. And that's making it public in number 1. I don't read number 4 making that clear. But if everyone else thinks it does, I mean, that's fine with me as long as the sentiment's captured. But
well, we're going to get to 4. So if the sentiment isn't captured, can you put a pin in that, Jennifer, to make sure when we get to revising the language of 4, that it does what I think everybody's trying to do with 4, which is what you're saying. We want the suite of recommendations here to make it clear that when the agency identifies rules, it should do so with public input, and publicly say what they're doing. So I want to make your idea not get lost. I just don't want to juggle too many balls at once. So if you could not forget that for us, that would be really great. All right, let's scroll back up to 1. Okay, so the second big kind of concept that we have is, do we mean by rules? Do we mean like, legislative rules? Do we mean interpretive rules? Do we mean something like rules in a colloquial sense, but we really mean programs? What do we even mean by rules or categories of rules? And how is it best to say this? And I'm just going to ask a question. Maybe this is somebody on the ACUS team. I assume we're not the first group that has had to deal with this conceptual problem. What we mean by rules. Is there another recommendation that says that kind of captures the concept that we're talking about here that we can cross-reference? Or are we going to create the wheel here about what a rule is?
I'm giving it some thought, Aaron. I mean, I think each one is probably a little bit different. I mean, we do have recommendations where, we, for instance, refer to the 551 definition of rules, and, that sweeps very broadly to include both substantive rules as well as, procedural rules and guidance documents and so forth. I mean, we could probably cross-reference that, but I think that's probably a question for the group, really, is do we want it to sweep that broadly here?
No, I agree. The group's going to decide substantively what we mean. I just want to know if we have off-the-shelf options that we can grab, not just one, but like, are there different types of things where they say, oh, this is a really broad understanding of rule, and we explain that in this recommendation. This is a narrower one. We have another, and then we can kind of choose among a menu of options. Or is this just going to be bespoke that we're going to come up with something here?
I think there are Reeve, I think there probably are recommendations from which we can draw. I mean, most of our recommendations either group rules into the category of legislative rules or guidance documents. I think those are our most commonly used terms, but we're not altogether consistent here. I mean, I think probably, Aaron, if I can just make a suggestion apropos of what Reeve has just said, is to get the committee's general thinking on this, and then the staff can revisit the language before the next meeting with an eye towards prior recommendations. That's what I would recommend.
Perfect. That makes sense. Robert?
Yeah, I'd just like to say that I think that if we were to put a definition of a rule right in the recommendations, that would probably bog them down and detract from the purpose of getting agencies to identify sort of as an empirical matter what sorts of rulemakings should be subject to retrospective review. But I think it would be a useful thing to put in the preamble. And we know that sometimes agencies have no choice. If it's subject to the Congressional Review Act, a rule is a final rule. But otherwise, I think that we should suggest that that agencies should decide what definitions apply to the recommendations, and then we can give them some options in the preamble.
Other reactions? I see Dave, take the floor, please.
Yes, thank you. One second, let me move you so I can be looking at you all. The hazard of a camera on the laptop. My thought is that perhaps in the identification process, there should be an explicit call out to the need to identify the appropriate scope of the periodic review, with perhaps a warning that a focus on a final notice of final rulemaking may be too narrow to accomplish the purposes of a periodic review, and that the agency may wish to expand the scope beyond those notices to encompass a broader programmatic or industry-focused kind of review.
Okay, so yeah, I think we have two ideas here. Robert's idea, as I understand it, is we should let the agency decide what they mean by rule, subject to the statute. But that should be that's actually a choice for agencies. What I'm hearing you're saying, Dave, is we should explain that as part of that choice, it doesn't have to be a narrow, like, uh, you know, formal rulemaking by
You
rulemaking
don't have to
list.
necessarily review only what you gave notice of 10 years ago. It should be.
It could be it could be programmatic.
Exactly.
Okay. But okay. So how best do I? First of all, does anybody disagree with this idea that that this is a choice for the agency, or I suspect somebody's going to say no. Agencies should not. This should not be something they can choose from. They should just do this generally for anything that falls within 551 of the APA, just a big understanding of rule. So thoughts, reactions from other members of the committee.
Sorry, just opening the floor. Aaron, should we still say that we have comments in the comment?
Yeah, please do. Please do comments.
Okay, sorry.
Kate.
Okay, sorry.
Kate is recognized.
Next time I will put it in there.
Perfect.
Yeah, I don't. It just feels like a little bit like unmoored just to not provide any kind of guidance. Like it feels to me like something that says, like just at a minimum, formal notice and comment rules and potentially beyond. I don't know, just something that says, because I just feels like a lot of threshold work to determine what is even within the scope of the periodic review, and the review itself is going to be pretty labor intensive if it's defined broadly. And I just don't know if you want to build that additional set of decisions into the process for every agency. That just, it feels like a big ask to me.
So this is a quick question I have for our consultants. When you were going through your interviews, how did agencies understand rule? Were they talking about legislative rules, something that goes through notice and comment, or were they talking about policy statements and things of that sort too?
This is Jonathan. I don't think that we specifically asked the agency staff we interviewed, is this also covering guidance documents or policy statements? My sense is that we were often talking about legislative rules, but that could vary under different statutes. So in the examples that we have in the report, for example, at U.S. Department of Agriculture, there's a review conducted every 5 years that relates to the Congress reauthorizing the Farm Bill, and that's even different from an agency rule. There might also be guidance documents that are in our list of examples. I would want to go back and check more specifically. But my other comment here, and of course Laurie might have an answer as well, but my other comment here would be that point 1 in the recommendations list could be asking the agencies to identify, anything that the statutes require that are subject to statutory periodic retrospective review requirements or periodic review requirements, and that may vary by statute. As we noted in the report, some of the statutes also use the word agency in different ways. The Evidence-Based Policy Act, the Regulatory Flexibility Act, and the Executive Order 12866 have slightly different definitions of agency. But in point 1 in the recommendations, I think it's asking whichever agency you are and identify what your activities include that are subject to statutory requirements for periodic review.
Okay, Bill, then Bridget.
Yeah, in as much as ACUS has made recommendations regarding retrospective review of rules before, I would like the staff to look and see if in any of those previous recommendations, any specification was made as to what they meant by rules there. Second, I would say that the idea of saying rule is broadly defined here, but that one of the grounds upon which you might decide whether or not to include it within your retrospective review regime might be that it's not a legislative rule, but is only a guidance document. That might be a consideration that you would take into account in deciding whether to do retrospective review of that kind of rule at all.
Thank you. Bridget?
Yeah, I like Bill's comments as well. And I think thinking about Dave Rosker's point, which I think is a really good one, I don't know that we have to deal with it necessarily in this first recommendation, because I think here we're talking about sort of a bigger scoping question. But I think a new recommendation in this same section might make sense to address Dave Rosker's point, and that would be something along the lines of, when planning for retrospective review, agencies should consider not limiting themselves to review of a specific final rule, for example, and instead broaden to consider entire regulatory programs as appropriate. And I can type that up for you, Leanne, if that's helpful.
That would be great. I missed the first half of it.
I know I did that really fast, but that's the point. It's just that I think, so I guess the question would be to Dave whether that's responsive to the point he's making.
Okay, so we can keep advancing the ball. Here's my proposal. I think what we need to do, and this is an ACUS staff between this meeting and next, figure out what we said in the other recommendations about retrospective review or periodic review, what we mean by rules, and then we can go back to this. My strong preference is for us, unless we've done it before, not to get into guidance documents and other things that are rules, but not legislative rules, because I think there might be different types of considerations to think about that. It sounds like that's not what we covered in the report all the way. I think we already have a pretty big project here. So my preference, though again, I'm just one member of the group, is unless we've already done this before, to keep this at legislative rules. And that might be something that we can think about in a future project, figure out how to take these good ideas we have for legislative rules and map them onto guidance documents, which I think raise separate concerns. But regardless, we can figure that out by next meeting once we have a better sense of what we've done in the past. So for now, let's leave this as kind of a placeholder, see what we've done. But unless anyone strongly disagrees, let's maybe kind of work with a soft intuition that we're talking about legislative rules here. Okay, I do like Bridget's idea of that comment. I think we'll get to that and we'll consider that language to see if that makes sense for us when we talk about what we mean by rules, that we're not limited to just rules, but we're looking at programs. So we'll get some language there. I don't think that's going to come right here. So I think, unless I don't want to cut it off conversation. If nobody else has any objections, I think let's talk about now Bill's point of what do we mean by periodic. So does anybody have a comment on Bill's point that by periodic, it shouldn't necessarily be a number of years, but instead it's something that could be sometimes or should always be, so I guess, subject to what the statute says, something that the agency chooses in the rule itself, saying this is when we think a periodic review makes sense. I guess maybe for Bill, I'll throw it at you. Is there a way that we could incorporate that idea? Because it seems to be that's a good idea. I don't know if that would be the only recommendation we would make, especially because Congress sometimes has said by statute, do it every X number of years. Is there a way that we can incorporate that idea without jettisoning the whole thing?
Well, first of all, Aaron, I think for recommendation number one, in as much as talking about what's subject to statutory periodic thing, I think we just leave it as it is, all right? The statutes provide what the statutes provide, and the agency just has to decide, which are in that category. When we get down to number two, this recommendation number two, I think there's a number of changes that will need to be made in any case, but I don't think we need to do it in terms of number one in any case. Okay.
Jonathan, can you save your thought for when you get to recommendation two then, if that's makes sense? Robert, is this about recommendation one or is it going to be about recommendation two?
Well, I have an idea for maybe resolving this, but in the header of recommendation three, so I can save it until then.
Yeah, save it there. All right, I would like to at least get one recommendation done today. So I guess there's Kate's thought. Kate, we've got rid of if any and put the any up there. Does that do the trick for you?
Yeah, that's great. Thank you.
Does anybody disagree with that language, that change? So we've got rid of if any, and we've just put any up top. If not, I say let's go with that, and we are done tentatively with recommendation 1, and we can move on to recommendation 2. All right, thanks everybody. All right, recommendation 2, Bill has a comment, Jonathan has a comment, and Robert has a comment that could be in 2 or 3, so I'll go that order. Bill, Jonathan, Robert.
Well, I'll start with the first sentence. For rules not subject to statutory periodic review requirements, agencies should decide whether to establish a periodic retrospective regime. I don't think they should decide whether to establish a periodic retrospective review regime. They should establish one, right? And then that regime would decide whether or not which regulations, if any, would qualify for retrospective review. I think we should distinguish between the regime that's set up and the actual regulations, identifying the regulations themselves that might need retrospective review. So I think we should establish the periodic retrospective review, and then in deciding which regulations should be subject to periodic retrospective review, they should consider blah, 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 et cetera.
Okay, I don't know if that, Jonathan, is your response on that, or did I jump the gun and your response is going to be on something different?
Yes, I can respond to that, and also to Bill's earlier point about the frequency at the same time.
Yes, please do.
Okay, on the point just made, I think the reason it was written that way, decide whether to establish, is that the report identified both pros and cons, or benefits and costs, of conducting periodic review, including that the cost to the agency, but also the potential cost to society, including instability of the expectation, the anticipation of repeated review. And so we say in the report, it may be highly desirable in many cases, but especially where there's rapid change, where the gains from learning are high, and where the costs to the agency and to society are low. So we don't necessarily, at least in the way the report is written, we don't necessarily advocate it for every rule or every agency program. That said, maybe that's in the meaning of the word regime, that perhaps Bill is suggesting that, you know, a regime could include very slow review or very infrequent review, as well as very frequent. Okay, so on the other point about periodic and being designated not only as every X years from the beginning, but with the period to be decided at each next retrospective review. I think that's an interesting and a good point, and it relates to the decision-making under uncertainty, the expectation of future learning. So we would also learn over time how frequently would be optimal, and that may change and be adjusted over time. But I think that's meant to be embraced in the discussion of periodic review, especially these discretionary periodic reviews in point 2 here, which are not already subject to a schedule set by Congress. We could make another recommendation to Congress. You know, maybe you should adjust the timing in your statutes, but at least for this number 2 about agency discretionary reviews, I think that was meant to be that idea that Bill has, which is, I'd be happy to see that reflected in the recommendation someplace, but you know, that's meant to be embraced here. Thank you.
Okay, Robert, and then John.
No, my comment is on 3, so I don't have anything on 2.
Okay, oh, great. Okay, John? John Cooney?
Thank you. Did the drafters of the recommendation consider adding a statement in 2 that for rules that are not subject to statutory periodic review, that in deciding whether to establish a periodic review regime, the agency should consider setting a limit on the number of rules that would be considered through the review process by limiting that review to significant rules or major rules or some concept like that. And in determining which rules are deemed significant, I think you'd have to honor Nina and Jennifer's point that it's important that the public comment on its views because they'll have a good understanding as to what they think is significant. And that could be of great use to the agency. I understand that restricting rules to be reviewed is implicit in the cost branch of the statement in number 2, where it's implicit that if the cost is too big, the agency might not pursue it. But I'd recommend having that set forth more expressly. I remember the effect of Clinton Order 12866 on OMB when it reduced the number of rules that would have to go through OIRA for review to those that are only significant or major. That change freed up Jim Tosey probably knows better than anyone. It freed up a lot of time and resources for the review process compared to the unrestricted review procedure that had governed before in Reagan Order 12291. And I think this would be especially important if you're talking about a continuous review process of some kind where all the rules would get cycled through on some schedule. If all the small rules are going to come through the process at some point, then you're really going to consume a lot of time and resources. And I'm wondering if any of the agency representatives on the call have a view about this. Because in my experience, whenever you tried to reach out and include everything, it was a drain on resources and it was never good for staff morale for the people who are going to have to deal with the less important rules.
It seems to me, I'm going to let people have a shot at it, that this idea could be incorporated in our list on three, where we go through things that they should consider, and they should surely consider the significance of the rule. That seems to me a factor that should be considered. I don't know if we need it here, but I'm curious what people think. Bill wants to respond to Jonathan, so I'll let Bill have the floor.
Yeah, let me first respond to John Cooney because I think that's right on the table right now. And that is, I agree with what he says. The difficulty is that number 3, as it's currently written, is about the frequency of the review, not whether there should be review at all. This is sort of with respect to those that we are going to subject to review, how often should we review it? That's what number 3's recommendation is. And 2 is the one that says, well, which rules should we actually engage in retrospective review? So I agree that that's where John's idea should come, but I don't know if it should be limited just to that particular subset. This is an area where I think more specificity about things that agencies might consider in deciding which rules to actually subject to periodic review should be placed. Responding to Jonathan, I agree that within the term periodic review, as you've put it out here, that my concept can be included, all right? But just as it was sort of a surprise to you, I think, to hear my recommendation, I don't think it would appear naturally to people that my recommendation would be something they could do under this system. So I think it would be worthwhile, if you think it's a good option, to be able to explicitly provide for my option as one of the things that they might do. And as I say, I don't want to wordsmith it here today. If there's support for that, generally I'd take up the pen and provide it well in advance of the next meeting for people to look at.
I see a number of people in the comments. Let's just for order of operations, I have no objection at all to seeing what Bill can come up with. I don't oppose the idea. So how about this? Does anybody oppose Bill's idea of trying to come up with a separate recommendation that we would add to the first tranche to try to articulate that idea? If nobody has an objection to that, then I'm going to say to Bill, go forth and circulate something that we can look at text-wise. Hearing none, I'm going to let Bill do that. Thank you, Bill. We appreciate your pro bono hours on that. All right, I see Amy. Amy, please have the floor.
Okay, I think I've got everything on now. I guess I'm a senior fellow, but I also work for an agency, and I'm thinking about this recommendation, and I'm assuming that we're issuing this recommendation because we're concerned that agencies aren't doing enough retrospective review or periodic retrospective review. And so I like John Cooney's idea. I think we need to make sure that we can focus it so that this recommendation actually supports agencies in attempting to do more of those reviews, if that is one of the purposes of this recommendation. So thanks, that's my comment.
Great, thank you. Anne?
I was just putting in some data in the chat. I mean, I'm happy to see what Bill comes up with, but according to the Congressional Research Service, if you look at final rule documents in the Federal Register, there's more than 3,200 a year in each year in the last two administrations. I guess it only goes up to 2019. So I do worry, kind of Jim and John's point about just the resource burdens on agencies if all rules are potentially de-universed.
So I'm looking at the language of 2, and I'm after hearing the conversation, my view, for what it is worth, is I would, for the first sentence, stick with the original language, because I don't think it's apparent that regime includes don't do something. I think regime suggests that the agency is going to do it, and sometimes for the reasons that Jonathan and Lori explained in the report, it doesn't make sense. So I think that we should leave it as a discretionary thing. I don't oppose the second part of that. In deciding which rules should be subject to the regime, agencies should consider the benefits. I don't mind that language. I think that language makes sense. So my recommendation would be to not change the first sentence, but to do change the second sentence. And then the third sentence, I don't think we need, because we've already given the agency discretion in the first sentence. Bill has Nina has a comment. Nina Olson.
I just think that I'm not disagreeing that we focus on significant, but I think that we need to give more guidance about what is significant, because I can see that a rule has truly significant impact on a narrow swath of the population and never ever gets updated, but it is creating enormous administrative burden and harm on that population. And so I think just picking up some additional factors, not just about the agency resources, but the impact on the public or the regulated part of the population or industry is very important. And I guess that goes back to the need for public input in this particular stage.
Okay, so if we keep public input, which I think we all agree that we need to have public input, do we need to say something extra in recommendation 2, or does the stressing that public input is essential for 1, 2, and 3 sufficient to address that concern, which I think is a very sound one?
I would actually like an acknowledgement, some more definition of significant. And part of it comes from, being in the Internal Revenue Service and the Regulatory Flexibility Act. The IRS has very rarely seen any rule that has ever required them to do any kind of analysis under the Regulatory Flexibility Act. They've just said, nope, there's no significant impact on the small business population. And you're like, how did you define significant impact? So that may be beyond the scope of this, but I just think directing that they think about the impact on the public would at least mean they have to check that box.
Okay. Bill Funk.
Yeah, I want to push back on your suggestion to keep the original first language, and a couple of reasons why. One, we have executive orders that say agencies shall do retrospective review of significant regulations. So it really shouldn't be up to an agency whether they're going to never do them unless they're statutorily required. They're required by the executive order to do them, various executive orders. So I don't see that they should say, well, we just don't want to do retrospective reviews, should be part of the issue here. Yeah, they should do retrospective reviews when appropriate. And that's what the regime should is set up, should identify when it's appropriate to do it. I completely agree with Ann O'Connell that We certainly don't want them doing reviews for all of the regulations. And that's what this regime is supposed to set up, which is to identify the category of regulations or individual regulations that will be reviewed, and the ones that aren't included won't be reviewed. And because the agency has decided on that. So I really think it's important to say that every agency should have the regime. Then we need to flesh out, and again, I don't think we should try to wordsmith it today, but I agree with everything people have said so far about the need to give some guidance about what kinds of rules should be subjected to the retrospective review. And then you get into recommendation 3, which is, well, all right, for those you've decided you get retrospective review, how often should it be, or how soon should it be? What consideration should you take into account? But it's,
Okay.
I really think it's important to keep require people to have the retrospective review, or at least.
Let's put that back on there. Agencies should establish, but now here's my concern, and I'm, I hate to throw it down there. Do we need to say, put an if any in there in deciding which rules, if any, should be subject to this review regime? We just took out if any in the first one. But I think maybe we need that there, because otherwise it sounds like we're saying that all rules should be subject to a regime, but the regime concept, as I understand what you're saying, Bill, sometimes means that certain types of rules don't have to be subject to periodic review.
Absolutely, yeah, of course.
Okay.
That's what the regime would. Maybe regime's the wrong word. Maybe we say a periodic retrospective review plan or system. The idea is you have a general system that is going to run your, tell you in the future, even when you get a new regulation, you look at this plan to say, well, is this new regulation that we've never seen before, is this one that ought to be subject to retrospective review?
Okay, let's do this orderly. We'll get to the question of significant at the end, John Coney's point. But are we okay with the language of the first 2 sentences where we say they should establish, and in deciding which rules, if any, they should consider costs and benefits? Anne?
I'm fine with that.
Okay. All right. When we see things happen in the chat function, I assume it means a call for comments and not just information. I apologize. Okay. So how about we do that? How about we say, and let's right now let's bracket plan system regime. We'll figure out between this meeting and next what we've done in the past. We'll figure that out. But we keep it. You should establish, but we're going to add an if any in the second sentence. Is that okay, everybody, for right now? We'll get another shot at it, but is that making sense? Kate, please.
Oh, I'm just gonna, I anticipate that I haven't been to a ton of plenaries, but I feel like at plenary, somebody's also always gonna raise the agency should consider establishing rather than should establish, as this is, potentially a little too directive. I think consider establishing would be more directive than decide, but less directive than establish. So another possibility.
All right, here's my general thought on that one, though again, I'm just one member of the committee. I think we should say, because I persuaded to do it because Bill's point that executive orders already require it. In that case, I think we can already say they should do this, given that everything we say is just a recommendation. But if they're already told by an executive order to do it, I'm okay with a little bit punchier. And if the council doesn't like it, they can come back and they can tell us that that's not going to fly. Does that make sense for you? I thought you were going to tell me the if any. I thought that's
no. I decided. I think it's actually a subtle difference, but fine here.
All right.
Actually.
Okay. Thank you. Okay. So let's go to that. Now let's do that last thought about public interest versus significant. How do we do that? I would like to finish 2 if we can, or at least have marching orders to figure out between this meeting and next for the team. Do we want to do significant? I understand what we're trying to do here. We're trying to say, agencies, don't drag your feet, really do this and think about the public benefits as well. On the other hand, significance also saying, like, don't waste all of your resources on this. It feels like this is a lot of stuff happening for kind of an introduction recommendation. Is there a tight way that we can balance these things? Does anyone have proposed language? Bridget.
Yeah, I mean, I wonder what Nina thinks about using the EO 12866 definition of significant. I mean, it's capacious and includes policy and novel legal and policy issues. It seems like it would do the job here.
Nina, did that do the job for you?
Yeah, I think that, you know, putting in something that, even if it's in the footnote, just some cross-reference to something that flags that issue is really what I needed to see.
I have a comment just on that.
Yeah, Jennifer, take it, please.
Yeah, so it turns out it's not to do with Bridget's. I actually concerned about using the EO definition of significance because I think some people could interpret or misread that as, you know, literally what OIRA deemed significant, you know, so what that particular, you know, administration thinks is significance, which I don't think anybody means to import or defer to whatever OIRA thinks. So I think that would be confusing. And I would go for any other route that use some synonym for that word. I think it's too loaded to put into this.
David's iPad. Who is David's iPad?
That's me, Dave Apel.
All right, take it.
So I'm getting late into this conversation, but I'm troubled that, just an observation, the findings of the report found that there have been requirements and recommendations for periodic reviews for years and years and years, and they're not being followed. And our response to that seems to be to make another recommendation to do periodic reviews. The other thing, and so I'm a little concerned, adding steps and procedures to before you even decide what to do a periodic review may be counter to our goal is to have more and more effective periodic reviews. I also noted in the findings the words from the agency is that the periodic they find it more effective to have a continuous evaluation of problems that the regulations are causing, rather than having an episodic burden, is what the kind of the language they use. Now, I realize that's in the context of a periodic review, but when we're establishing the timeframes for review early on and requiring it, it seems to be ignoring the finding that what has really worked well for the agencies is a continuous evaluation, and then doing a rewrite when they find there's a lot of problems, such as what Department of Transportation does, which is to decide to do a periodic review when they find that we've had a increased number of requests for exemptions or explanations. That's evidence that maybe you need to redo that. And so basing the determination to do a review on evidence rather than or on questions being raised seems to be contrary to the concept of let's establish a schedule or regime for periodic reviews. It seems like we're losing that the value of the ongoing review, which the report found pretty significant.
Okay.
Yeah, I know.
I'm trying to think what to do with that. I agree. I think, though, that if we define the word periodic to include, you know, it doesn't have to be every 5 years. It could be like, you know,
right,
biannually or you know, every whatever to look at it to get there. So I think I agree with you, but I think we can put that in recommendation 3. So put a pin on that and see if we can do that in 3. I want to finish 2, at least a draft here. I don't have the sense of the room. It's hard for me to do this on Zoom. My reaction, and I could be outvoted here, and that's fine. My reaction is, I think that if we have the comments, which we're going to say, where the public's going to be part of this, all of this gets kind of bogged down. And if there's a value in raising the level of abstraction, and I kind of like the simplicity of not getting into all of this here, where we would just say they should consider the benefits. I'm fine putting public benefits. So maybe agency consider the public benefits of periodic review. and the costs, including administrative burdens, and ending it there. And if we get into all of this other stuff, or more recommendations and more thoughts so they can consider, it's going to turn into like a, like a manual rather than a recommendation, rather than a principle. So for me, I would say let's keep the first two sentences and not do anything about limiting to significant rules or whatever that's already inherent in administrative burdens. Or move to preamble. I see staff says that. Does anybody oppose my objection? Here, I don't want to be a bully, so I really want to listen. But it just seems like if we start going down that path, recommendation 2 will never end. Steph, do you want to take the floor? I've not heard from you for a while.
I was just going to say, I'd like both of the concepts, and I think that they're important, involving the public and figuring out which rules should be reviewed. I think has real benefits in terms of saving time on the agency's part, and also bringing attention to issues that are pain points for members of the public. And similarly, I think that looking at the entire corpus of an agency's regulations regularly could be too much of a burden on the agency. So just from that agency resource perspective, in terms of thinking about making this operational, I think those are both important factors. But if we're worried about the recommendation getting too bulky, then I think that we could say, agencies should consider various factors and include a factor that, might encompass the burden on the agency. So we have administrative burden here. And then in the preamble, we could explain that public involvement relates to both administrative burden, the need for an update to regulations, which might be captured by the potential gains for learning. And then we could discuss scope, the scope of the recommendation in the preamble as well. So just a suggestion, but I do support both of the concepts.
Does anybody disagree with that? At least for now, we'll get a chance to come at this. But for me, I think that makes sense. But again, I'm just going to say that it's really hard for me to run a meeting when I can't even see all of you. I don't want to be a bully. If I'm being a bully, someone speak up. But if not, let's do that, and we'll look at it, and we'll have a chance in 2 weeks to decide if it makes sense there. Going, gone. Thank you. All right, so that's what we're going to do. Now let's look at number 3, which I think is important. Let's, and maybe want to add some stuff here. I just want to say real fast, as I'm looking at number 3, my 2 initial proposals would be agencies should consider, comma, among others, because I'm sure we don't mean this list to be exhaustive. I would put that there. And then on E, this might be for the consultants. Do we say less complexity may warrant more frequent reviews? Or wouldn't it be greater complexity may warrant more frequent reviews? Is that just a typo, or is there a content here that I'm missing?
Aaron, this is something that actually was pulled from a previous recommendation, and we had some debates over the use of the word complexity internally, and we received a comment on the use of the word complexity. So this might be something for the whole committee to discuss.
Okay. All right, then I'm going to pause it there. So let's go A, B, C, D, and D down the line then, if it's not just a typo. A, does anybody have any comments, changes, or I guess the preamble to this 3? Does anybody have anything about either 3 or 3A? Okay, preamble, Robert.
Sure. In light of Bill's concern, because the word periodicity implies a fixed durational cycle, and sometimes we just need to be a little more flexible, could we delete periodicity and just use the word frequency?
I'm always okay deleting periodicity because I don't even know how to use the word. So I'm okay with that, but anybody else want to push back on that? Okay, great. Thank you, Robert. That word should not exist, so thank you. All right. Anybody else about that or A?
Okay. I think that it should be on A, the pace of change of the technology, science, the sector of the economy or population affected.
I think that makes sense. I surely agree with that. Okay, Jonathan.
Yes, consistent with that last point. I think in the report we say not the pace of change of not only technology, science, economy, and population, but of society. So there might be demographic or sociological changes that are also relevant. Perhaps the word population captures some of that. Something like the word society would be good there.
So instead of population or with population, what do you mean by that? Do you want a replacement or an addition?
I suppose a possibility would be to say the pace of change of technology, science, the economy, or society affected by the rule.
Okay.
Just trying to make it broad.
Yeah, I agree. Nina, does that make sense for you?
Yes, it achieves what I wanted, what I was concerned about. Thank you.
Yeah, and I think that's a very good catch. We definitely, it's more than just the economy. I appreciate that. All right, hearing no further thoughts, let's look at B. Does anybody have comments on 3B? Okay.
We did receive a comment on 3B.
Oh, what is that? I'm sorry, I didn't see that.
It's in the bubble, so it's really.
That's right, my chat function is blocking that so I can see who's in line. Okay, let me see. Certainly about the distribution benefit may also warrant more frequent reviews. Is that not included in the term accuracy? An estimate? I don't think we were only saying, I mean, I would assume that the estimate includes the distribution estimate, right? All right. Does anybody want to propose language there? I'm inclined to keep what we have because I think we include that. But if anybody wants to champion the language, I'm happy to listen.
Aaron, this is Steph Tatham. We looked at this issue.
Please.
Yeah, we looked at this issue in the Committee on Rulemaking yesterday, and I think it may be that this discusses uncertainty about benefits and costs, but under OMB Circular A4, we also recognize transfer impacts, which may be distributional. So maybe just adding transfers, benefits, costs, and transfers would help to address the IPI concern. Yeah, or you could add other distributional impacts.
Benefits, costs, and transfers.
Or distributional impacts.
Distributional impacts, yeah, maybe a little more readable.
In more plain language.
I don't mind because I think that concept is already included in the words estimate and accuracy. So I don't mind adding it if we think that it's helpful to us. Does anybody feel strongly one way or the other?
I think we should keep the distributional impacts in there.
Okay. All right. I have no objection to that. I don't have a problem with it. Sounds like people like it. Okay, let's go to C. Anybody thoughts on this one? Okay, hearing none, let's go to D. This is one where I know we have a comment on this one. And the comment, as I understand it, they're saying, look, just because there's a large volume doesn't mean you should change it. And that's surely correct. Like you can imagine, as they explained in their comments, like they didn't like it before, they still don't like it, and they don't like it for the same reason. Okay, that's fine. I guess my thought though is this is only things you're supposed to consider, and we could try to say something like, you don't have to do it, but that's inherent in the word consider, I would think. I see some comments though. So, Robert, do you have a comment on this, or is that a stray D?
No, I actually would prefer comments, complaints, or suggestions and omitting the word petitions, because otherwise I think we're implying that that under 5 USC 553E, there might be some right to petition for retrospective review, and I don't think we need to go there.
Okay, let's say that we'll circle around. I see more people on the line. Kate?
I wonder if you could respond to the concern about, just a kind of rehashing of arguments lost at the initial rule issuance stage by just saying something like new comments, right? New comments, complaints, or suggestions, then you wouldn't have to sort of provide too many more words. But
I like that. Though, I mean, I guess that invites, what if it's new comments, but with, or an old comment with new data? But maybe that counts as a new comment. All right, Bill?
Well, I think just the number of complaints is worthy of making it consider it more frequently. I wanted to, the petitions I'm sure was referring here were petitions for rulemaking that had been made. In other words, if you received a lot of petitions for rulemaking to change the rule, that might suggest you should do a more frequent review of that rule. But I think complaints and suggestions includes petitions, so I guess I don't have a real problem with that. But the fact that there's a greater number may warrant more frequent reviews, I think that's a true statement.
I think so too. I don't want to be dismissive of the concern, which I get, but we're only talking about a consideration, and surely it can be rebutted like anything else. But the volume is a relevant consideration, it seems to me. So I'm inclined to say, get rid of petitions for the reasons that Robert said. That makes sense to me. Not necessarily add new, even old is still useful information that that's worth considering. But just recognize that they don't have to do it if there's not a good reason to do it. But maybe I'm just wrong on this one. Bridget?
Yeah, I wonder what do you guys think about just cutting that first sentence? Because I think the second sentence gets at the point, right? If people are asking for you to change the rule in any way, in any venue, in any format, you should probably consider that as you think about which rules might need another look.
I always like to cut. That makes sense. Jonathan?
Oh, thank you. I think the spirit of the comment that we received there is that, as you noted, Aaron, that it's not about just the number of comments, complaints, suggestions received, but the content of them, whether they present new information, new evidence. So maybe it could say a greater number of requests for new evidence. Maybe the word evidence is even better than information, but new information or evidence regarding would help capture the point that's in the margin comment in a constructive way.
Okay, Bill, and then Anne.
The idea of taking out the first sentence that was suggested, I mean, it would make it unlike all the other recommendations here, which have a general statement and then a sort of a greater this or lesser that would have this impact. So, I mean, I think you need the first sentence.
Anne?
I'm worried about the second sentence. It seems in administrative law, the number of comments or the number of petitions shouldn't matter. I mean, it doesn't matter in our standard kind of arbitrary and capricious review. I don't know if that's the majority opinion of the group, but it seems like the substance should matter far more than the number. And there are also issues with regard to regulated entities and regulatory beneficiaries there about who's going to be the one submitting all these comments, requesting review.
Good points.
So what if we said comments, complaints, or suggestions received from stakeholder groups or members of the public, a greater number of requests or new evidence? How about we just say new evidence regarding changing the rule may warrant more frequent review, and not get into the number, because again, we're already considering comments from this. It often feels like we're just saying the same thing different ways. I think it's inherent in the first sentence. What do you think, Jonathan? Does that make sense for you?
Yes, I mean, it seems like the new evidence or added evidence would encompass the number and the quantity and quality of the inputs from the stakeholders and public.
That makes sense to me, but Bill, you say a response to Ann.
Yes, I mean, I agree with her that when you're considering a rulemaking and a lot of people say, do it this way, and that's not a justification for doing it that way. I agree with that. But here we're just talking about whether or not to consider something. And the fact that you have a lot of people who are upset about something is a reason, I think, to consider it. It may not be a reason to change it, but it may be a reason to consider it. So I still like a greater number of requests as one of the bases for saying it's a reason to consider reviewing it more quicker than you otherwise would. It doesn't mean you change it, but at least, if people are really concerned, a lot of people are concerned about it, I think you ought to take that into account as being something to consider in the frequency of the review.
Do you disagree, Bill, that concept is inherent in the first sentence, though? Comments, complaints, or suggestions from the stakeholding groups and members of the public? Surely that includes the volume.
Yes, I agree, but by putting new evidence, you're saying you're doing just the opposite of what you're substituting the content for the number, and I think the number is itself a relevant consideration in terms of just whether or not you got to look at the frequency of looking at it.
Okay, this is a disadvantage of the Zoom format because I have no possible way of reading the room and seeing what faces look like. Anne, you have a comment. Can you take it, please?
Maybe it goes back to sort of how we started the whole meeting about internal versus external and sort of who's making the decisions. I guess I worry about the explicitness in the second sentence, creating incentives for certain groups more than others, in a sense, to kind of put it crudely, kind of game the system, and it's going to have sort of asymmetric effects on retrospective review. And so, I mean, definitely, you wouldn't want to eliminate it entirely. And I do think the first sentence captures that. But I guess you need this balance between sort of internal agency decision-making about retrospective review, of course, with some external public input. But I may just be off for where my viewpoint is compared to the rest of the committee.
Robert.
Yeah, I understand the greater number of requests that's supposed to really get to level of interest rather than robo comments. Could we say level of public or stakeholder interest or new evidence regarding changing the rule may warrant more frequent reviews?
I like that a lot. Eloise has left the call, but that is an Eloise level comment. That's great. I think that's very helpful. Does that make sense for you, Bill and Ann?
Yes.
Ann?
Yes. So sorry, I put my video on and was nodding my head to help you with reading the room.
I'm sorry. My screen is this is impossible, but I'm doing my best. Thank you. All right, we're almost done. I was hoping that we were going to finish all of the tranche one. That was overly optimistic. We're not even through with 3. We have a comment from Bridget on 3D. This will probably be the last comment we have time for, and then we'll pick this up again.
I'll make it a good one. Okay, so what do you think about adding something about requests for waivers or exemptions somewhere in here? Because that's sort of a signal that the apparatus is causing some trouble out there. And that's like another form of input that you might get from the public.
Comments,
it's the problem is it goes one direction. It's sort of complaining that it's too strict, whereas you might want to add something else. We're complaining that it's too lax. That's the only problem with what I'm offering, I think.
Well, I think it's inherent in the word complaint.
Yeah.
All right. Well, we have reached the hour, and I don't want to keep anybody longer than what we've said. So I'm going to end with our thoughts here. We're going to have the staff look at some of the past ones to make sure we're good on rules. I asked the group to review this again and think about it. If you have some proposed language, feel free to send it to the team. We'll pick this up again. Hopefully, we'll pick up a little bit of speed next time, but sometimes it just takes time. So thanks, everybody. I appreciate it. And I will see everybody in 2 weeks. Thanks all.